I'm Alex Chitwood, an attorney in Warner's Real Estate and Corporate Practice Groups. I represent clients in commercial transactions, including performing due diligence, preparing closing documents, and aiding with the drafting and negotiating of purchase and sale agreements. And I represent both landlords and tenants on leases and related documentation.
And I'm Ben Nimphie, an attorney in Warner's Corporate and Government Affairs Practice Groups. I represent business clients in a wide range of transactional matters, and I also represent government entities in strategic planning and other issues. Today, Alex and I will be talking about critical things to consider when it comes to leases in the cannabis industry. We'll talk first about important considerations from a landlord's perspective, and then we'll shift gears and think about what cannabis business tenants should think about when considering a lease agreement with a landlord.
There are, of course, many different aspects to consider when it comes to entering into a lease agreement as a landlord. A fair number of lease considerations overlap with conventional commercial leases. In other words, most of the same concepts you want to consider with a normal commercial lease would still apply to a lease with the cannabis company. However, what I want to focus on today are specific provisions you'll want to think about that are especially significant when leasing space to cannabis companies. I'm going to talk about 5 key areas: licensing requirements, zoning, inspection rights, early termination provisions, and knowing your tenant and knowing your mortgage. The first area we'll talk about is licensing requirements. Cannabis is a highly regulated business, and the legal and regulatory landscape is constantly changing at the state and local levels. In all cases, however, a prospective tenant will need to have all of the appropriate state and local licenses in order to operate its business. Oftentimes, however, a tenant may be required to secure a lease before all necessary licenses can be granted. As a landlord, it's important to make sure that you build in a contingency for your prospective tenant to obtain all the necessary licenses. This can be structured in a number of different ways, but the key is that you build in some flexibility to terminate the lease if the tenant doesn't get the required licenses before occupancy or within a specified time frame. The second area we'll talk about is zoning. Along with the licensing requirements, local zoning laws are generally quite strict in terms of where cannabis businesses can be located in a city, township, or other municipality. Landlords will want to make absolutely certain that the property is located within a zone that permits the type of use the potential cannabis client intends to use the property for. If you want to know more about the zoning process or how to work with your local government on obtaining special use permits, you can check out Warner partner Tom Ammon's video on that subject. The third area we'll talk about is inspection rights. Traditional commercial leases often contain provisions that allow landlords to enter the premises upon reasonable notice to a tenant in order to inspect the property. With cannabis businesses, it is even more important to ensure that this right is built into your lease, as different cannabis operations require different state and local licenses. However, keep in mind that some local laws may restrict a landlord's right to enter a premises, so review local ordinances to make sure your inspection rights provisions are compliant with local law. The fifth area we'll talk about is knowing your tenant and knowing your mortgage. Obviously, knowing who you're going into business with is important. Lease agreements are business transactions, and although it's always important to know who you're doing business with, it's even more crucial in the cannabis industry to know and trust the people and the businesses you contract with. Does the tenant have a solid payment history? Have you run a background check? Are all the necessary licenses current? And is there any past litigation or payment issues involving the potential tenant or an affiliated entity of the tenant? These are just a few of the questions landlords should be asking. Understand your own mortgage documents as well. Many commercial mortgages contain provisions that put a borrower in default if a premises is used for illegal activity. Because marijuana is still a Schedule I controlled substance, it is not yet federally legal, it could put a landlord's mortgage in instant default if a building is leased to a cannabis tenant. Banks frequently allow cannabis occupants to amend their mortgages to allow specifically for cannabis tenants, but it's important to talk to your bank before leasing to a cannabis occupant. Of course, there are many other issues that landlords should consider when negotiating leases with cannabis tenants, and those issues will vary in their levels of importance depending on your specific circumstances. But hopefully this list will get you thinking about how to best protect yourself as a landlord to cannabis tenants.
And speaking of tenants, I'm going to flip this around and talk about important issues you'll want to consider as a cannabis business when you're thinking about leasing property. As a tenant, there are a number of things to consider, but at the top of your list should be consent requirements, termination provisions, dispute resolution provisions, and knowing your landlord. So the first thing that I'd like to talk about is consent requirements. And what I mean by consent requirements is that frequently in commercial leases, a tenant is required to get a landlord's written consent before entering into certain types of transactions or doing certain types of work to a premises. For example, it's not uncommon for a commercial lease to require a tenant to obtain a landlord's consent before making modifications to the premises. Alternatively, we frequently see leases where a landlord's consent is required when a business entity tenant undergoes a change of control. Tenants should strongly consider how much oversight they're willing to deal with for a particular landlord. Some landlords will want to have more oversight than others, but for tenants, it's important to understand in which scenarios you'll be required to get your landlord's consent. The second thing is termination provisions. And as Alex said, landlords will want flexibility to be able to terminate a lease when it suits them. As a tenant, though, you'll want to know and understand all of the different circumstances under which your landlord can terminate your lease. Often in the cannabis space, landlords will negotiate hard for the right to terminate a lease if a tenant fails to obtain a necessary license within a specific time frame. However, the cannabis licensing process can be difficult, and it can often hit roadblocks, causing significant delays. So understanding your lease's termination provisions and working with your landlord to negotiate reasonable terms is essential to make sure that you're not unexpectedly asked to leave. Number 3 is dispute resolution. It's almost always better to settle disputes out of court if possible. In the cannabis business, this is even more complex because marijuana remains a Schedule I controlled substance. Solid dispute resolution provisions are crucial in cannabis leases to avoid ending up in federal court. Because of marijuana's current status as a Schedule I substance under federal law, if a landlord-tenant case ends up in federal court, it could be thrown out by the judge because of the nature of the cannabis business. And finally, number 4, know your landlord. This is not really a legal issue per se, but for the same reasons Alex discussed earlier, for landlords, it's crucial from a tenant's perspective to know who you're doing business with. You of course want to do business with people and businesses you get along with, but even more important in the cannabis context, where landlords are much less likely to take a hands-off approach to management. Because of the constantly evolving nature of cannabis laws at the federal, state, and local levels, it's important to have a landlord you know and who is willing to work with you if and when legal goalposts are moved.